is the discretion of the court. So you need to remember. That's why sometimes public asks you, why do you have this kind of range of sentencing? For example, for sometimes it provided for fine. After that, it provide for imprisonment. Okay, it's either fine or imprisonment. Okay, in some circumstances there will be a range of fine. For example, in some offences, for example, for the human trafficking. For human trafficking, for example, there will be a fine and also mandatory imprisonment. Okay, so how to impose fine? How to impose fine? So in imposing such sentencing, the most important part would be the public interest, and the proper sentence that need to be passed will be in order to serve the public interest in two ways. First, it may deter others who might be tempted to try crime as seeming to offer easy money on the supposition. Okay, and secondly, the public interest indeed serve and best if the offender is induced to turn from criminal way to honest living. Okay, so this is very important in the case of R versus Ball. So the public interest is very important for that in that sense, right? So it was also emphasized in a few cases after that. For example, in the case of New Takshan versus PP, in which the judge say that the public interest varies according to time, place, and circumstances of each case, including its nature and prevalence. Okay, so this is very important. It depends on the time and place. If you can see that in terms of what happened in the past, the crime that took place in the past is quite different compared to what happened now, currently. Okay, we have quite a number of cases involving the cheating and fraud through online portal. Okay, and that is something which is quite recent compared to those days. Even some may say that even the crime for corruption, in the crime for corruption, if those days that by tapping phone, because you need to know that MACC, those days they try to they tap the phone, so they know the conversation between the suspected person and the victim. So in those days, actually they ask for bribe in a very direct ways. In a very direct ways. But nowadays, in terms of asking for bribe, they are not going to ask directly. Okay, it will be in the form of, let's say, inducement, for example, any present given to the public officer. So this is also quite challenging for the prosecution as well as the investigation officer. Okay, there are a few things that also you need to know in terms of in the case of PP versus Loh Chung Fat. For example, in this particular case, the offender aged 20 pleaded guilty to a charge for a possession of heroin, and he was released on a bond for good behavior under section 294. So there are a few considerations at that particular of time in which you can see that under section 294, the court actually took into consideration that at that particular of time he was aged 20. He was 20 at that time, and he pleaded guilty, so it is actually saved the court's time and also public resources. Okay, so the prosecution actually applied the revision to the High Court, and the judge say that the mitigation factors and the public interest as reflected in legislation, okay, has been considered by the court, meaning that two factors, mitigation factors and also the interest reflected in the legislation, in which the court in that particular situation had reversed the decision by the lower court, in which at the lower court the the court had granted a bond for good behavior under section 294, but when it comes to High Court, the High Court say that the court had reversed the sentence, which is from the bond of good behavior into the sentence of 6 months imprisonment. Okay, so if you can see from that particular case, the High Court say that that the session or the magistrate court often incline quite naturally to be over sympathetic to the accused person. Okay, and this is normal. And also the mitigation submitted by a convicted person will normally bring up problems of family hardship and other usual problem of living. Yeah. However, the correct approach is to strike balance as far as possible between the interests of public and the interests of the accused person. Okay, so meaning that at the age of 20, if you are able to have a possession of heroin, in which normally for drug cases it seems to be rampant. Yeah? So it is a rampant nowadays, even for the young people. Also, they can have if you have an access to a drug, which means you involve in the very beginning, in the very beginning of your life, in that particular crime. Okay, so this is very important, right? Okay. To see about this particular situation as well, the court in the case of PP versus Ramakrishnan Subramaniam, if you can see at the page 543, page 543, in that Baljit Singh, PP versus Ramakrishnan Subramaniam, it is regarding 5 respondents were charged with causing the death of the deceased with the intention of causing bodily injury, which was sufficient in the ordinary course of nature to cause death, okay, thereby committing culpable homicide not amounting to murder under section 304A. So this is quite different under section 302. Culpable homicide, normally it did not have any element of premeditation, meaning that preparation by the accused person. So they, all of them, 5 of them, was charged under section 304A instead of section 302. So in this particular case, Justice Azhar Mohamad, which is now the Chief Justice of Malaysia, Chief Justice of Malaya, had set aside the sentence passed by the High Court and substituted with a heavier sentence. Okay, meaning that something's actually goes wrong with the sentence by the High Court. And this is because to take into consideration few things. Because 5 of them committed cruel act against the respondent in causing the death of the deceased, in which it had not been given due appreciation by the learned judge in considering the sentences that should be imposed on them. So although the learned judge had touched on the principle of public interest, this was, however, not reflected in the sentence imposed. So even the judge say that the cruelty factor should be an aggravated factor to impose a heavier sentence for the sake of public interest, instead of giving priority of the excessive consideration to the fact that respondent were young offender. So the court actually had rejected the contention or the mitigation by the accused person that at that particular time that he was young age and should be given opportunity. Okay, but the court said no, because of the cruelty and for the sake of public interest. Okay, the judge had erred in law, and the cruelty factor is the main factor that could impose a heavier sentence for the sake of public interest, instead of giving the priority against the respondents as a young offender. Okay, and also the accused person also mentioned about, because they are young, they are breadwinner in the family, so they need to so it will cause a family hardship. A family hardship if, let's say, that they were imposed with that particular sentence. Okay, so it depending on the situation, and it depending on the public interest, it depending on various factor. If you can see on the case of PP versus Muslim Ahmad, in this particular situation, the respondent was 55 years old at the time of committing of the offense. He had no previous conviction, and as a businessman, a terms of imprisonment would have an adverse effect on his business. So the court actually grant him the court in the first place grant him a binding over, meaning that bound of good behavior under section 294. But at the High Court level, okay, at the High Court level, the court actually, the High Court had set aside the Session Court decision because in this particular situation, Muslim Ahmad actually committed an act against the Communication and Multimedia Act, Section 233, which is posting offences, comments against Perak's government official portal. Okay, so a binding over order would send a wrong message to would-be offenders and public at large that offensively uncontrolled and virulent comments can be indiscriminately posted on the internet without any or serious repercussion. So this is also very important because I know that you guys are social media savvy. So please beware of each and every posting that you've been handling. Yeah. So PP versus Muslim bin Ahmad, it is a 2013 case. It is the best described about the factors of the accused person being 55 years old at that particular of time, and he should be given an opportunity because of the factor that he is a businessman. So, but again, public interest is against the individual interest. Okay, right. In the sentencing principle, you can see that I mentioned to you that in each and every phrase, there will be terms of past sentence according to law. And I mentioned to you last week that whatever it is basically on the principle of law, and it will be according to the provision of law itself. So that's why it's very important if, let's say, you have decided to charge that particular person with any offences, it is very important that the passing of sentence must also according to law. If not, then there will be excessive and abusive powers of the judiciary, which is subjected to an appeal. Yeah? So you have learned about the jurisdiction of the court. Yeah? The court have the jurisdiction, criminal jurisdiction to hear the case, and criminal jurisdiction to decide pertaining to that particular case. Okay, so by having that jurisdiction, the sentence that may be passed by the court must be according to the law. If it is not according to the law, meaning that it will be in excess of their jurisdiction. And in excessive, in passing sentence in excess of jurisdiction, meaning that the court had actually gone or overboard. So this is a very important aspect, right? Okay, still we are actually discussing about the sentencing part, okay? And if you can see that maybe one of the issue would be how to assess the sentence to be passed. Yeah? How to assess which sentence appropriately to the accused person. So this is very important because just want to share with you, when I was with the bench, I was a magistrate before, and during my early days, I think the first few months, during at that particular of time, when I just being appointed, okay, and after that, then they gave me one particular court for me to handle with few cases, okay. So at that particular of time, there was not enough training. It is just depending on the lectures notes, for example, okay, and it will be quite difficult how to assess the appropriate, okay, the appropriate sentence to be passed, okay. So the court need to make some consideration, okay, in assessing the appropriate sentence to be passed. And in the case of PP versus Ja'far bin Daud, the judge Muhammad Azmi J had mentioned a few guidelines. Yeah? For example, where the convicted person is the first offender, the magistrate is required to call for evidence on the accused regarding his background, antecedents, and character. This is in line with section 1294 and also section 173A. Okay, the consideration whether the accused person should be given a bond of good behavior or not. Okay, but whatever it is, where the convicted person has previous record and admit them as correct, the court must consider whether the offence or offences committed previously were of a similar nature. It must be a similar nature, okay, because sometimes the accused person may have the past record And the past record, you must remember this, the past record must be something which is related to the current case that he's been charged with. Okay, and the court must then consider the sentences imposed in the previous conviction for similar offences to determine whether they have had any deterrent effect on him. Okay, where he is found to be a persistent offender for a similar type of offence, then it is in the interest of justice that a deterrent sentence should be passed. Okay, so in this particular case, the court enhanced the accused sentence from 8 months to 18 months imprisonment because of the possession of 0.21 gram of heroin, and he had 5 previous convictions, 2 of which were of possession of drug. Okay, so this is the very important part in the case of PP versus Jaafar bin Daud. Okay, which considered to be the judicial principle, right? All right. Again, you need to see in the case of what happened if it involved the minor offender, the minor offender. Okay. So you can see that if let's say that the accused person is the minor offender or juvenile under the age of 21, and if found guilty, then a probation report must be submitted. You remember last week I mentioned to you, if let's say it's involved any juvenile offender, or if the accused person is below 21 years old, okay, then there will be a probation report that need to be submitted. Okay, that need to be submitted. What is a probation report? Probation report meaning that the child has been put under probation. Okay, or the welfare officer. The welfare officer actually prepared a report about the background of the accused person. It's the family background, the academic background. Okay, what actually happened towards the accused person. Yeah, and the court need to need to admit that particular report. Okay, whether or not to send the accused person, this particular young offender, okay, to be detained in approved schools such as Henry Gurney until he attained the age of 21. Then this is by virtue of section 76. That's why for child offender it's quite it's a little bit different. It's a little bit different. The difference is actually if it is involved young offender, normally young offender of course may be subjected to certain sentences, type of sentences, but you cannot send the young offender for a death sentence. You cannot send the young offender to death sentence. But young offender are subjected to imprisonment and also whipping. But that should be the last resort. Okay, that should be the last resort, because for the young offender, the salient feature would be the possibility of that particular person, the possibility of that particular person or offender that can be put under rehabilitation to be changed. Okay, to change themselves so that they can go back to the society and to have the good attitude or to have the good manner. But again, depending on what charge or what offences that involve them. All right. Okay. Apart from probation report, for other offender, they will have a victim impact statement under section 173 M2, okay, of the CPC. Okay, the victim impact statement is actually very important for for the person, for the victim to be involved in the process of the sentences. Okay, sentencing, because may be taken into consideration. For example, in case of Ahmad Rashidi Zainul and another versus PP, in terms of to take into consideration the gravity of the criminal offense of a gang robbery, to emphasize and also to capture the mind of the judge about the traumatized and the inconvenience of the victim, because the victim is actually a 76-year-old lady which was too afraid to stay alone in her own house and always required a companion to be with her. Okay, certainly this has caused inconvenience, and so to meted out the sentence, proper weightage has to be given towards the victim impact statement, and it is also something which the sentencing need to be enhanced, not because the factor relating to the victim alone, but rather the nature of the crime, which is the gang robbery, which must naturally meet a heavy and not a lenient sentence. That's why for gang robbery, if you still remember under section 392, 397 of the Penal Code, okay, there is a classification or differences in terms of sentencing. If the robbery took place in the morning compared to the robbery took place at night, okay, if you still remember. And the heavier sentencing need to be imposed towards the accused person if the the act of robbery being committed during the night days. Okay, right? Okay, is there any question so far? All right, if there is no question, okay, you guys can still hear me?
Yes, sir.
All right. There are some.
Yes.
Okay, very good. Okay, very good, Alia, Ashraf. Okay. Um, um, in terms of appeals against sentence, there are some. There will be some issues, because if you can see that there will be terms in which what we call as appeals against sentence and also revision. Okay. As for the introduction, maybe you can see under page 550, in which there will be classification of you are going to appeals against sentence and you are going to lodge a revision, okay, in terms of the correctness, legality, or propriety of any sentence passed by inferior court. Okay, so there will be no issues in terms of appeal against the conviction, okay, because conviction and sentence are two different things. You may be convicted and pass with certain sentence. So when you actually appeal to court, higher court, the appeal actually more towards the appeal against the sentence. So you can see under case of Bandulananda, Bandulananda Jaya Tilake versus PP. I believe that he's Bangladeshi or Sri Lankan. So the federal court held that the appellate court will not normally interfere with sentences unless it is satisfied that the learned judge passed a sentence which is unlawful or contravene with the established principle. So whether it is harsh or manifestly excessive, it depends again on the how the learned judge exercise his discretion. Okay, and it will depends on the how far. If the sentence so far outside the normal discretionary limits as to enable the court to say that the imposition must have involved an error of law. And the court say that in that particular case, there are some factors that need to be considered. So the judge say that sentences do vary in apparently similar circumstances with the habit of mind of a particular judge. Okay, because sometimes I think just want to share with you my 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 experience when I went to the when I visited. I was with the bench after that, and we have this particular program. We visited Kajang Prison, and we had opportunity to mingle around with the Banduan, with the Banduan in that particular session. They have a session, and that Banduan is a Banduan which has been convicted with drug offences. So I still remember that that prison officer asked the Banduan if they have any question that they want to ask, because in front of you there is a judicial officer which comprised of prosecution and also the magistrate. So if you have any burning question that you may ask, and surprisingly, one of them actually asked. They say that, look, I've committed with that offence, with this particular offence under the under DDA, Dangerous Drug Act, which is the same and similar charge with my friend. So he showed his friend standing near him. Okay, we committed the very same offence. But how come I get heavier sentencing? I was sentenced, my sentence is heavier compared to him. Okay. In my case, I was sentenced 9 months imprisonment. He was sentenced with 5 months imprisonment. So if you read in the case of Bandulananda Jayatilake, the federal court say that the sentences do vary, yeah, in apparently similar circumstances with the habit of the mind of the particular judge. And the reason also, the court says again and again, it will be normally depending on the judicial discretion. Okay, judicial discretion. Okay, because you can see that even the judge has a room for reasonable differing opinion, yeah, as to what is to be preferred with. Okay, so this is very important for you guys to note. Okay, right. We have few other cases for the appeal against sentences in which we are going to discuss later on. All right, boleh? Okay, there are few meaning as well in terms of the terms used. For example, shall be liable to or shall be punished with. Okay, so what will be the differences? Okay, in the case of the terms of shall be liable to, you can see in the case of, for example, PP versus Man bin Ismail, in which the accused person was convicted under Section 3 of the Vagrant and Discrepit Person Enactment, which provided offender shall be liable to imprisonment for 6 months. So there is actually options of a fine. And the learned magistrate stated that he was compelled to sentence the accused person to imprisonment. And the accused person, and the prosecutor actually go to the High Court for revision. And the High Court actually quashed the accused conviction and sentence and say that it would seem that the learned magistrate who tried this particular case was under impression that because the section provide that every person found guilty of an offence shall be liable to imprisonment for 6 months. Therefore, he was compelled to pass the sentence of imprisonment. However, many mitigating circumstances might be present, and if that was his impression, then in my opinion, he was under entirely wrong impression. Because to my mind, meaning that the High Court judge say that, to my mind, they give the court an absolute discretion whether to award sentence of imprisonment or to deal with any probationary provision under Section 294. Okay, so it does not mean that if there is no provision regarding bound over, because there is no provision regarding the bound over, okay, Section 294 and Section 173A is not something which has been provided under the Penal Code. Okay, you carilah dalam manual Penal Code sekalipun, dia tak menyebut berkaitan dengan Section 294 as a part of the sentence. Okay, sentencing. Okay, but it does not mean that you cannot impose bound over to the accused person. Okay, we have a few cases, even in rape cases. In rape cases, there are numbers of cases in which the accused person has been found not guilty, although there is a penetration. Because in let's say in rape or sexual offences, in rape cases, the penetration must be as such to be proven, okay, must be proven to be effective, okay, effectively supported with the forensic and corroborated evidence, okay, supported with corroborated evidence. Because the nature of, let's say, the nature of the offences requires, for example, the penetration to be proof. Okay, if the penetration cannot be proved, you cannot say that the other person committed rape, for example. Same goes to the sexual assault. You may say that somebody actually had touched you, okay, in the lift. You have no other witnesses. We have quite a number of cases. If the lift have the CCTV, then the victim are lucky enough. Okay, but if the lift do not have any CCTV, then what is the avenue for the victim? It's his word against his own word, for example. Okay, so the corroborative evidence is very important. That's why you learn about law of evidence, because corroborated evidence is very important in the case of sexual offences and in the case of in which the forensic evidence must be relied upon. Okay, so that is there are a few others case that you need to read, and we will discuss this during the tutorial starting of today. Okay, so what that is shall be liable to. So what will be different? What is different between shall be punished with? Okay, shall be punished with. So you can see that court are still in conflict as to the meaning of shall be punished with, because in some cases, the court have held that the phrase shall be punished with means that the punishment is mandatory, and the court has no discretion and no binding over order under section 294 CPC can be made. Okay, so they will be at the crossroad lah. The judge actually at the crossroad whether the court will impose the particular sentence under section 294 or not. Yeah? In the case of Philip Lau Chi Hang, the accused was convicted for the offence of exhibiting a firearm in a manner likely to put any person in fear of death at the time of committing robbery. Okay, maknanya during the commission of robbery, the accused person actually showed a firearm. Yeah? So it is something considered to be wrongful under section 4 of the FIPA, and it shall be in that particular case, the law say that shall be punished with imprisonment for the life and with whipping with not less than 6 strokes. And the session court as a first instance court imposed a sentence of 3 years imprisonment and a whipping of 6 strokes. So the accused person appealed against the sentence, and the public prosecutor actually sought for a revision for sentence was illegal. The High Court dismissed the appeal but allowed the revision, surprisingly. Okay, the High Court dismissed the appeal of the appellant but allowed the revision sought by public prosecutor on 3 main reasons. First reason would be the court say that when the section 4 mentioned about shall be punished with imprisonment for life and with whipping with not less than 6 strokes, okay, then it is a mandatory. It is a mandatory. The sentence for life imprisonment is a fixed one, and it is not the maximum that may be awarded, so that a lesser sentence of imprisonment may be imposed. Okay, so you can see that the first point of the High Court judge say that it is a mandatory. It is not a choice. It is not a discretion. It is a mandatory. Secondly, the High Court say that it is the general rule that the High Court in doing or exercising its revisionary powers does not enhance a sentence even though illegality was committed by the lower court. Okay, and the third one, having regard to the mandatory sentence enacted under section 4 and having considered the facts which fell within the section, the 3 years imprisonment is clearly improper and unauthorized. Okay, so the court say that, look, if the law mentioned about that mentioned about shall be punished with imprisonment for life, then there will be no discretionary powers. Okay, let us see next under the case of PP versus Leonard Glenn Francis. The accused person was convicted of offences under section 8 of FIPA, which provide that the offender shall be punished with imprisonment up to 14 years with not less than 6 stroke of whipping. Okay, so there will be and number 2, unlawful possession of 14 round of ammunition, okay, peluru, which is liable in respect, which is punishable under section 8A and shall be on conviction be liable on respect of such contravention to imprisonment for a term not exceeding 7 years and to a fine not exceeding 10,000 ringgit. So what happened, the court actually ordered the accused person to be bound over for 10,000 ringgit with 2 sureties under section 294. And of course, the prosecution appealed because the prosecution said, look, there is no discretion upon because it is a very important and very serious case in nature. So In that case, the High Court actually substituted the bound over under Section 294 with a sentence of imprisonment and whipping not less than 6 strokes, because the court say it's quite long, it's quite long decision. But in the gist, the court say that it is very important that to take into account the public interest rather than the interest of the accused person. Okay, the important part will be the public interest will be the most important part. Yeah. So yeah.
Doktor minta maaf kalau saya masuk lewat. Doktor dah terang tadi. Maksud bound over ni macam mana?
Yes. Okay. Bound over under Section 294. Bound over ni which mean that there will be no Section 294. Bound over ni which mean there will be no sentence imposed against the accused person. Accused person will be released. Will be released on the good behavior bond. He will not be sent to prison and he will not be convicted with any fine. Okay, and the important part would be meaning that he will be released on good behavior bond for 2 years, for example. So in that particular 2 years, in that 2 years period, he cannot commit any other offences within that duration of time. So he can stay at home, okay, main PS2 for example, okay, or monthly he will go to the police station to report himself, okay, with or without sureties, ada ataupun tidak bersama dengan penjamin. So you can see under Section 294, okay. So the issue would be if let's say that Section 294 ni nak digunakan pada masa bila, okay, kita adakah Section 294 tu sebahagian daripada hukuman? Jawapan dia, ya, Section 294 tu adalah sebahagian daripada hukuman. Kalau misal kata kita dapat lihat in the case of Jayanathan, in the case of Man versus PP, okay, you can see that it is something which is it seems that Section 294 ni adalah salah satu method of sentencing, okay. Cuma court say that kalau misal kata it involves serious offences in nature, and if the law of that offence, you ingat saya bagi tahu last week kuasa untuk menghukum, the powers to pass sentence adalah something which is it is something discretionary powers. Discretionary ni must be based on two important things. First, it must be based on the public interest, okay, and it must be based on the legal principle, okay. That is the first part, okay. Secondly, the discretionary powers will be based on what that has been provided by that particular section or that particular law. If the law say that the accused person upon the conviction shall be punished, in the case of Philip Lau Chi Hang, muka surat 557. Kalau misal kata you baca kes tersebut adalah di mana dua pertuduhan yang dikenakan pertuduhan yang dikenakan terhadap accused person. In the case of PP Leonard Glenn Francis, kalau kita dapat lihat di sini, accused person has been charged, page 558, PP versus Leonard Glenn Francis. Accused person has been charged with two offences, which is one under FIPA and one under Arms Act. And the session court granted him a bound over under Section 294. So prosecution go to the High Court and say that, look, it shouldn't be like that. And the session court exercising had erred in law. Okay, maknanya telah terkhilaf. You tak boleh kata court salah tau. Kalau misalnya kata practice as a lawyer, nanti court kata, adakah saya salah? Adakah court salah? You tak boleh kata, oh, court telah melakukan kesalahan. Tak. Court tidak melakukan kesalahan ni, walaupun kata bahawa insan ini adalah insan kamil, dan court juga adalah hakim, adalah manusia. You cannot say that he was wrong. That's why the law and normally the way they plead, they will say that the court actually had erred in law, telah tersilap dalam melaksanakan hukuman. Okay, so yang kita bincang tadi adalah shall be punished with. If let's say the law has specifically provided, if the accused person, if convicted and shall be punished with imprisonment, okay, life imprisonment, so which means there will be no room for discretionary powers of the judge to give the bound over under section 294. Okay, boleh ke Husna? Macam panjang pula sikit So 294 maksud dia adalah you will release the accused person on the good behavior bond without the accused person being sentenced, being put behind bar. Okay, it's a form of kata orang macam okay, awak didapati bersalah, jadi kalau begitu maknanya awak akan dilepaskan dengan bond berkelakuan baik sebab there must be a reason. For example, the age, the health of the accused person, the offender, it must be taken into consideration before the judge gives section 294 bond over. But it is a very rare situation. Okay, in practice, it is very rare. Sangat-sangat rare di mana accused person katalah dalam 20 cases belum tentu satu kes pun accused person akan dilepaskan dengan bond berkelakuan baik kecuali dia tidak ada rekod lampau, antecedent or past criminal record. Okay, kecuali kalau accused person tu memang the first time offender. Kalau first time offender, dia akan pergi pada section 173A. Okay, 173A it is a bond of good behavior as well. Tapi the accused person will not be convicted. Okay, boleh? Husna, okay?
Okay, Doktor.
Alright, okay. The rest, okay. Cuba tengok berkaitan kes Nordin Yusmadi bin Yusuf versus PP. Page 560. Okay. In this case, accused person ni telah pun charged with offence of rape under section 376. Okay. 376, yeah. So the Court of Appeal allowed the appeal against the High Court decision which set aside the order of the Session Court, yeah. Which imposed the mandatory minimum terms of imprisonment of 5 years provided under section 376, although the accused person is a useful offender. Okay, we have quite a number of cases sekarang ni berkaitan dengan kes rogol, whether just to inform you, we have quite a number. Kita ada banyak kes sebenarnya berkaitan dengan kes jenayah seksual yang sedang berlaku di Malaysia. So bila berlaku keadaan tersebut dan dia melibatkan, if let's say that the offender ataupun si pelaku tersebut adalah merupakan orang muda, useful offender, whether it is correct or not to put him behind bar for a long time of period. In this particular case, the High Court had reversed, had set aside and imposed mandatory minimum terms of imprisonment of 5 years, because under 376 you must remember, under section 376 you must remember that the victim's age will be taken into consideration. Okay, the victim's age. For example, if the victims is somebody who less than 21 years old, okay, a minor. If you rape a minor, it is a mandatory for you to be sentenced for an imprisonment. Okay, because section 376 has been amended, which actually had cast away the discretionary powers of the court, and to replace with the new particular sentence in which, if let's say that the victim is a minor and you committed that particular offense, okay, so you can be imprisoned for a very long time, which is 5 years. 5 years imprisonment is a long time period, okay. So it's no more 1 or 2 years, okay. So that's why it is very important to see and to look that the circumstances of the case, the circumstances of the case is very important, okay, because taking into account that although that the accused person is under 21 years old and above 18 years old, this is something which is also very important in terms of age of majority. If let's say the accused person is above 18 years old, 19 or 20, in which he is also below 21 years old, he will be subjected to the Juvenile Court Act 1947, in which the Child Act as a young offender and need to be what we call it, he need to be detained. Okay, he need to be detained at the Henry Gurney School, for example. Okay, and it is wrong to say that the accused person, by having such youthful offender, therefore the sentencing that should be imposed would be the lighter one. No. Okay, there is no such circumstances, or there is no such situation. All right. There are some other, for example, maximum sentence provided by law, okay, in which, as I mentioned to you, it will provide a maximum sentence. Somehow, ada juga law mengatakan between minimum and maximum. Ada juga law yang memberikan the range is only the maximum sentence. Okay, so this can be seen from a few cases here. Regarding the type of sentence, there are how many types of sentence? How many type of sentences? How many types? How many type of sentences? Who can answer my question? How many type of sentences? There are 8 actually. There are 8 type of sentences, which is first and foremost death sentence. Okay, death sentence. Yeah. However, there will be some exceptions to the death sentence. You can read under page 562 until 563. There are quite a number of sections relating to death sentence under various offences. Under Penal Code, for example, under the Dangerous Drug Act, under the Firearms Increased Penalties, which provided for a death sentence. But there will be some exceptions. You cannot pass the death penalty towards the pregnant woman. Okay, you cannot pass the death sentence to the child and young person. Okay, this can be seen from section 275 of CPC and section 97 of the Child Act 2001. Okay, we have the famous case of Lim Hang Seo. Okay, Lim Hang Seo, the famous case. If you learn about, I'm not sure you come across this case for your criminal law. Yeah, Lim Hang Seo, he was 14 years old. It was in 1978. This is the case in which the accused person has been convicted under section 57 of the then ISA, in which for offences of possession of pistol and ammunition, for which there is only one sentence authorized by law for each the offence, which is the sentence of death. The death sentence was commuted. He was passed with that particular death sentence, although he was 14 years old at that time. Okay, because you can see this was in the case, this was in the year of 1978. 1978, meaning that pada masa tu we just baru saja selepas kes melibatkan komunis. Okay, dan dalam kes melibatkan komunis tersebut kita dapat lihat bahawa Lim Hang Seo telah pun dituduh membawa pistol dan juga bom di tengah-tengah bandar Kuala Lumpur. So sebab itu dia telah ditangkap dan telah dihukum dengan hukuman gantung. He was the first child offender yang telah dikenakan hukuman gantung. Bukan dikenakan hukuman gantung, tapi telah dihukum dengan hukuman gantung. Tetapi tetapi Yang di-Pertuan Agong telah pun memberi pengampunan, royal pardon, and the accused person has been sent to Henry Gurney School until he attained the age of 21 years old. Okay, so we have another case of PP versus Kok Wah Kwan. In this particular case, the accused person is 12 years old and committed murder under section 302, which is punishable under death sentence. And the Federal Court restored the finding of the High Court, which convicted the respondent and detained him during the pleasure of Yang di-Pertuan Agong, because he is still at a young age. All right. Okay. So pardon board will play an important role if, let's say, that at the end of the day, the death sentence has been pronounced. We have we have quite a number of cases. For example, in Mona Fendi case, Mona Fandli case and Juraimi case, in which they actually, it took more than 10 years for them to be hanged. That is our criminal justice system, to make it fair, because we have a problem. Not say the problem, because if you can see that the human rights activists, especially the group, feel that there will be no, it's not right, for us to take the life of the others, to take the life of the others. Okay, although that particular person committed an offense. Okay, so that's why in America, for example, there is some states, they do not have any death sentence, and to replace death sentence, the accused person will be sent for a life imprisonment. Okay, but the problem occur when there is no death sentence. There will be a continuously murder case in the prison. Okay, and at the end of the day, they took their own life. Yeah? And this is something which you can see that in Malaysia, although we have a death sentence, although somebody may say that we have a cruel system of criminal justice, but it is not like Singapore. It took 10 years for Mona Fandli to go to make an appeal, up until from the High Court to Court of Appeal to Federal Court, and up goes until the royal pardon. Okay, she applied the royal pardon to Sultan of Perak, Sultan of Pahang at that time. It was rejected, and he applied for a pardon, royal pardon, to Yang di-Pertuan Agong, and it was rejected. So it took around 10 or 12 years until she was finally she was finally hanged at the Kajang prison. All right. So that is for death sentence. Please be mindful of Section 281, the procedures of the execution of death sentences. Section 281 of the CPC. For imprisonment, we have that is the second one. Imprisonment, there will be imprisonment for life, imprisonment for a fixed period, imprisonment for concurrent or consecutive. Concurrent or consecutive. So what does this mean? Imprisonment in the form of fine. There are 4 types of imprisonment. First is imprisonment for life. What does this mean? Imprisonment for life means imprisonment for 30 years. For 30 years with a remission of 1/3 of a good behavior. Okay, meaning that if somebody has been sentenced for imprisonment for life, imprisonment for life means 30 years. But if let's say that he actually shows a good behavior in the prison, he will get a discount. A remission means a discount of 1/3 of the 30 years. 30 tahun punya imprisonment. You can see case Cik Ani binti Itam, Cik Ani bin Itam. That is imprisonment for life. Secondly, imprisonment for a fixed period. I think this is straightforward, in which every sentence of imprisonment shall take effect from the date on which the sentence was passed, unless the court otherwise direct. So this is also very important. The computation is either the sentence that will be passed, whether it depending on the date in which it was passed, okay, or at the date of the arrest. Okay, kalau misal kata at the date of the arrest, maknanya kalau dia telah ditahan selama 2 tahun sehinggalah dia didakwa di mahkamah, contohlah kan, kalau dia ditahan selama 2 tahun, meaning that if let's say that you feel that that's why in passing sentence you need to see how long the accused person has been detained. Okay, berapa lama agaknya accused person tu telah ditahan, because somehow or other the accused person telah pun ditahan sementara penyiasatan, in which sometimes it take more than a year, for example. So you should take this, you should consider that particular facts. Okay, so you may see also Section 292 subsection 1 of the CPC provide that if the accused is an escaped convict or is currently serving a sentence of imprisonment, the second sentence may take effect immediately, which is concurrent, or after he has served his imprisonment or consecutively. Okay, it's either concurrent or consecutively. Maksudnya concurrent itu maksudnya dia boleh jadi accused person didakwa atas dua kesalahan. Contoh di atas dua pertuduhan. Okay, he was charged under two charges, and after that the court found that he is guilty for that both charges. Okay, so the court may say that under section 292 the court can impose the sentence immediately, meaning that concurrently. Penjara 2 tahun bagi kedua-dua kesalahan. Contoh ataupun it will be consecutively. Maknanya penjara 2 tahun bagi pertuduhan pertama dan penjara 2 tahun bagi pertuduhan yang kedua. Ada beza tak? Ada beza tak berkaitan concurrently and consecutively? Guys, is there any different?
Ada.
Ada. Apa beza dia?
Beza dia hukuman yang untuk concurrent tu dia sekalikan, means dia kena penjara 2 tahun. Tapi consecutively ni dia akan tambah lah 2 tahun tambah 2 tahun. So meaning 4 tahun lah.
Yes, betul. Maknanya dia punya sentence akan menjadi lebih lama. Dia punya hukuman penjara lebih lama. You can see a few cases. For example, in the case of PP versus Oi Wang San, okay, in which the respondent and 3 others pleaded guilty to an amended charge under section 304, read together with section 34 of the Penal Code, for the culpable homicide not amounting to murder. The High Court ordered 10 years imprisonment begin from the date of sentence was passed, at which time the respondent was serving a sentence of imprisonment. Okay, so the court actually say that the law on commencement of sentences of imprisonment on prisoner already undergoing imprisonment, as in this case, is provided under section 292. Maksudnya dia tu sebenarnya sedang menjalani hukuman penjara, tetapi pada masa yang sama dia didapati melakukan kesalahan di atas pertuduhan lain. Jadi hakim tu mengatakan bahawa okey, awak didapati bersalah dan akan dihukum dengan hukuman penjara 10 tahun bermula daripada tarikh hukuman itu diputuskan. Pada masa itu beliau sedang menjalani hukuman penjara. Okay. Jadi pihak pendakwa raya telah pun membuat rayuan ke atas perkara tersebut. So the court say that the discretion of the court will depending on the facts and circumstances of each case, whether to order the commencement of the sentence on such convicted person immediately or at the expiration of the imprisonment to which he has been previously sentenced. In this case, the court sentenced him to 10 years to take effect to the date of the sentence, since he was due to be released in 2001. Okay, and in that case, dia telah pun jatuhkan hukuman 10 years in 1996. So there would be an overlapping of several years. Maksudnya kalau tak, dia sepatutnya akan dibebaskan 2001, tapi oleh kerana dia telah jatuhkan hukuman 10 years, maknanya dia akan keluar pada tahun 2006. Okay, ada tambahan lagi 5 tahun. Maknanya dia dah 96, 2001. Oh, okey. Maknanya dia akan ada tambahan kepada jumlah penjara tersebut. Jadi in this particular situation, pada pandangan hakim rayuan, this does not reflect the gravity of the offence, sebab dia ada 13 previous conviction from 1986 until 1992. Okay, so the court accepted that the present offence was serious and that this was pre-planned and that it occurred in prison. So actually it is public interest demand that the custodial sentence to commensurate with the offence, and sepatutnya 10 tahun penjara tersebut hukuman penjara tersebut hendaklah dilaksanakan kepada accused person sepatutnya selepas dia dibebaskan pada tahun 2001. So isu berkaitan Section 292 adalah berkaitan concurrent ataupun consecutively. The court say that sepatutnya dalam kes PP versus Oi Wang San, oleh kerana accused person ni ada 13 previous conviction, so the sentences should be take effect consecutively. Maksudnya selepas dia dibebaskan pada tahun 2001. Okay, bukan semasa dia menjalani hukuman. Okay, so concurrent ataupun consecutive boleh juga lihat berkaitan the vital issues dalam page 566 ya. The next vital issues concern the court determination in ordering the sentences to run concurrently or consecutively if there is more than one sentence of imprisonment. Concurrent and consecutive sentences are only relevant to imprisonment and not to whipping. Okay, sebab kalau whipping ni, nanti later on kita akan lihat bahawa whipping ni dia ada sedikit perbezaan. You tak boleh menambah jumlah whipping. Sebab whipping ada section 288. Paling tinggi pun adalah 24 strokes. 24 kali sebatan. Okay, 24 kali sebatan. So you tak boleh nak kata okay, oleh kerana dia menjalan didakwa sebagai bersalah sebagai bersalah kerana kes murder kerana kes rape maka dia perlu dirotan 5 kali bagi setiap satu pertuduhan. So 5 kali bagi setiap satu pertuduhan dia ada 10 pertuduhan. So dia akan disebat sebanyak 50 kali. Okay. So kalau dalam undang-undang law mengatakan bahawa 24 stroke. Nanti kita akan bincang berkaitan dengan rotan. Dan you can see berkaitan dengan concurrent and consecutive sentence are only relevant to imprisonment and not to whipping. In the case of PP versus Peter Ting Cheong Kin. If there is more than one sentence imprisonment, the court must make it clear whether they run concurrently or consecutively. And determining whether charges are concurrent and consecutive, the court may use the one transaction principle or totality principle. Okay, so this is something which very important for you guys to know. Whether concurrent or consecutive, the court may use the one transaction principle or the totality principle. This actually we can see under section under the case of PP versus Yap Huat Seng. The complainant was a girl who was 17 years old and her sister was 13 years old. The respondent and the 3 other male persons threatened and robbed the complainant and her sister of their jewelries and cash. After that, each of the 4 persons, including the respondent, took turn and raped both the complainant and her sister. So ni macam gang rape lah ya. The first and second charges preferred against the respondent were 2 charges of rape, while the third and fourth charges were 2 charges of robbery. The respondent pleaded guilty to all 4 charges. So now the learned president of the session court sentenced the respondent to 3 years imprisonment on each charges and ordered the sentence to run concurrently. So the public prosecutor, being dissatisfied, appealed. So it was held that the sentence are to run concurrently if the accused is convicted of the principal offence and a subsidiary offence. In this case, the accused was convicted on 2 counts of rape, which were distinct offences, and on 2 counts of robbery, which were also distinct offences. So the court allowed the appeal and enhanced the sentence as follows. The first charge, respondent is sentenced to imprisonment for a period of 5 years plus 3 years of stroke rotan. And on the second charge, 8 tahun penjara plus 3 years stroke of rotan. And both of these will run consecutively. Okay, consecutively. What does it mean by consecutively? Secara kerana beratnya kes ini, dia akan dijalankan secara berasingan. Okay, faham tak berkaitan kes ini? Dia berkaitan dengan one transaction principle ataupun totality principle. Okay, totality principle ni, you kena lihat juga berkaitan sama ada accused person tu dituduh di bawah has been charged under which particular offences. Dalam kes PP versus Yap Huat Heng, this involved the victim, 2 victims, one 17 years old, one 13 years old. And you must remember that the accused person is a minor. Sorry, the victim is a minor. So when it comes to the victim as a minor, this will become a statutory rape offences. Okay, So, and furthermore, this is a gang rape and gang robbery. So that's why they're being charged. The accused person being charged with two charges. The first charges is pertaining to the rape. The second charges is pertaining to robbery. Okay, so bila dia mengaku salah, dia kata bahawa okay, saya mengaku salah. In mitigation, mengaku salah ni kira apa? Dapat apa kata orang tu? Dapat he expected ya. Bila dia mengaku salah, maknanya dia akan dapat hukuman lebih rendah. Tetapi the court say that look, it depending on the circumstances, public interest, and in this particular case, the court say that look, it is two distinct offences. When it is two distinct offences, you cannot say that you cannot say that you can get the lesser sentence. Okay, so in this particular situation, the court say that look, because of you have been charged with two charges, okay, so you will be sentenced differently. Okay, taking into account the totality principle, although it is one transaction, so dalam one transaction tu, iaitu rogol dan juga rompak, the accused person hendaklah dihukum secara consecutively, iaitu secara kata orang tu secara berbeza. Okay, so in total actually the accused person has been sentenced with 10 years imprisonment. Okay, and this is justifiable to order that the sentence run concurrently. Ya. Dan ada kes iaitu kes Ayub Abdul Jabbar yang telah mengikut kepada keputusan ini. Okay, kes Ayub Abdul Jabbar ni adalah accused person was charged with an offence of resisting lawful apprehension. Dia cuba untuk kata orang tu resist lawful apprehension under section 224, nak melarikan diri daripada tahanan, and 4 charges of housebreaking, pecah masuk rumah. And the trial court ordered the sentences of imprisonment to run consecutively, a total of 17 years, and the accused had to pay 12,000 ringgit. And the court in this case say that each distinct offence must be dealt with separately when imposing sentence, and offences in respect of infringement of the same section of the particular law must be regarded as distinct if the offences were committed against the different person or at a different time or at the different places. Alright? Okay? So, ada soalan ke?
Doktor,
Yep.
yang section 403, 404, yang 409, 420 tu ataupun dikenali sebagai youthful offender, kan dia kena rotan berdasarkan badan disiplin sekolah. Siapa yang akan jalankan rotan tu?
Badan Disiplin Sekolah?
Yang section 403, 404, 406.
Okey. Baik, kalau melibatkan youthful offender, dia akan dirotan. But however, rotan yang dimaksudkan di bawah section 402, is it?
403.
403. Okay, you boleh tengok kes Chai Ah Kau actually, Chai Ah Kau. Dalam kes Chai Ah Kau, at one trial, the accused person who was 18 years old was sentenced to 18 months imprisonment and 10 stroke for armed robbery with 3 others. So at another trial, he was sentenced to 3 years imprisonment and 10 stroke for another offence. So counsel appealed as the accused was the youthful offender and the maximum number of stroke is 10. So the High Court in Singapore held the accused person was not youthful offender as he was under 16, as he was over 16, and if there is 2 distinct trial, so the 20 stroke was well within the maximum of the 24 plus 24 stroke for an adult. Okay, bagi adult, hukuman rotan akan dilaksanakan oleh pihak penjara. Kalau melibatkan section 403 sampai section 402, whipping ni akan dijalankan oleh sekolah. Yang dimaksudkan dengan sekolah ini adalah sekolah Henry Geni. Okay, dengan hukuman rotan yang ringan. Hukuman rotan yang ringan ni bermaksud the type of rotan tu will be different. Okay, compare kepada type rotan yang melibatkan orang dewasa. Okay, So itu maksud dia. Okay. So for useful offender, jumlah rotan tidak boleh melebihi 10 kali sebatan. Right? Tidak boleh melebihi 10 kali sebatan. So if you can see that, laju sangat Faiz tanya ni dah sampai ke rotan. You can refer to page 572 berkaitan dengan whipping. In which in terms of whipping, you can see that how whipping is carried out. Section 288 provide that the number of strokes shall be specified in the sentence and the maximum number of stroke for adults is 24 stroke, while for useful offender is 10 stroke. And the size of cane shall not be more than ½ inch in a diameter. However, it will be different compared to the useful offender. Okay, because useful offender, school discipline ni bukan bermaksud sekolah biasa. Dia bermaksud sekolah Henry Geni, the approved school. Kira juvenile, juvie school. Okay, and it will be kata orang tu they will be the whipping, the exercise of whipping will be in front in the presence of medical officer. Okay, in the presence of medical officer. Dan bila kita melibatkan case whipping ni ataupun rotan, it must be careful lah. It must be careful sebab bila kita kata rotan, normally whipping is imposed where there is evidence of violence or brutality. Okay, maksudnya in the case of, for example, in the case of sexual offences, okay, di mana memang ada whipping as a sign of violence or brutality yang terlibat dalam case tersebut, dan dia dikategorikan sebagai corporal punishment as well. Kalau misalkan kata corporal punishment should not be imposed, then whipping would be the best whipping is the best mechanism, because there will be a tendency of the penal procedure and reform is certainly against the imposition of corporal punishment, and whipping ni would be in other hand, again it is not, kata orang tu, the aim would be not just retribution but also deterrent. Okay, for the offender. At the same time, it will be a model, bukan model apalah, maksudnya a lesson for the rest not to commit the same offences. Okay, boleh ke Faiz?
Very clear, Doktor. Terima kasih.
Sama, alright, okay. Tadi adalah concurrent dan consecutive. Nanti you boleh lihat kepada apa yang dimaksudkan dengan concurrent dengan consecutive ni. Kita akan bincang dalam tutorial. Lepas tu kita ada imprisonment in the form of fine. For this you may see under section 283, 2831B dan 2831C. For example, kalau misal kata maximum term does not exceed 6 months, so the term shall not exceed maximum terms of imprisonment. You can see that kalau misal kata apa maksud dia? Maksud dia kalau misal kata dia ada dua maksud. Maksud pertama adalah if let's say that the offences is punishable with imprisonment, there will be a maximum terms and the term that shall not exceed. Okay, you can see that dalam Rajah 14.134. 14.135 ni maksud dia adalah kalau misal kata adanya hukuman denda, tidak pakai topi keledar, tidak ada lesen, contoh paling mudah lah, lesen expired, kita pun tak perasan kan, PKP macam mana kita nak renew lesen kan. So kita kata orang tu didakwa di mahkamah dan dihukum dengan hukuman denda. Contoh hukuman denda does not exceed RM500. Okay, law provided that kalau misal kata orang itu gagal membayar a maximum of RM500 punya fine, dia hanya boleh ditahan tidak lebih daripada 1 bulan penjara. So this is something which in prison in default of fine. Kalau kegagalan membayar denda, maka ia bermaksud orang itu boleh dipenjarakan. Okay, itu maksud dia. Okay, dan jumlah-jumlah tu adalah fix di bawah section 2831C di bawah 14.135 page 571. Other factor adalah the court must state clearly whether the imprisonment in default of payment of fine should run concurrently or consecutively. Contohlah kan Perkara paling mudah adalah contoh kita park kereta tanpa letak kupon. Tahukah kita kalau misal kata kita park kereta dekat tempat yang sepatutnya kita ada kupon ataupun tempat berbayar di tepi jalan, kalau kita gagal, kita boleh disaman sebanyak RM300 oleh mahkamah. Dan kalau kita ada 10, katalah kita ada 10 kesalahan yang sama, so dia adalah berjumlah RM3,000. Okay, dia berjumlah RM3,000. So katalah kalau ada 10, so hakim kata okey, dia denda RM300. Tak bayar, jika tidak bayar 1 bulan penjara. Okay, sebab dia di bawah does not exceed RM500. So 1 month imprisonment. Okay, so kalau kita ada 10, dia akan jadi bila? Dia akan kalau ada 10 pertuduhan, RM300 setiap satu, dan gagal 1 bulan penjara bagi setiap satu. The magistrate should specify. Okay, the judge should clearly state whether that imprisonment should run concurrently or consecutively. Kalau tak, orang tu akan kena penjara 10 bulan. Okay, atau 1 bulan sahaja. Okay, maksudnya kalau concurrently, 1 bulan sahaja untuk 10 kesalahan. Kalau consecutively, dia akan jadi 10 bulan untuk keseluruhan 10 pertuduhan. Okay, so this is something that you need to know. Imprisonment in default of a fine. Whipping. Okay, whipping ni adalah satu yang saya dah bincang tadi oleh kerana Faiz Ashraf bertanya. Okay, so you boleh lihat ya. Dia berkaitan adalah section 286. Okay, lepas tu when whipping should be imposed. Ini juga dapat dilihat ya. Whipping should be imposed when. Okay. A sentence of whipping is usually imposed in case of violence against other person. But you can see that in the case of 290 versus PP, Vietnamese ni kot. The applicant was sentenced to 100 days of imprisonment and 2 strokes of whipping for an offence under Section 3(1) of Immigration Act. Maknanya dia masuk secara salah, tidak ada pasport ataupun visa. The applicant sought revision on the correctness of the sentence. The High Court held that the punishment of whipping is to be reserved only for crimes involving violence and brutality. So, ini pun satu pendekatan yang kita katakan bahawa sepatutnya macam dia kata crime against brutality lah ya. Kalau tak perlulah kita whip orang tersebut, kita sebat orang tersebut ya. Lebih-lebih lagi kesalahan dia adalah melibatkan kesalahan memasuki negara tanpa ada pasport atau dokumen yang sah. Okay, so but this is something which again depends on the facts of the case. Okay, macam dalam kes Tung Naing Ong ni, dia merupakan Tun Naing O versus PP. He was a Myanmar refugee and would serve no purpose to whip the applicant after serving imprisonment because he will be deported back to his country. So sepatutnya sentence of whipping was set aside and the imprisonment still remain. So it depends on the particular of the case. Normally in practice, whipping ini akan dibuat secara serentak. You tengok kat situ section 288 Section 288 mengatakan bahawa the maximum is 24 stroke. Tapi dia tak kata 24 stroke tu hari ni satu, esok satu, lusa satu. Tak. 24 stroke tu in one day. Normally you akan disebat. Offender akan disebat ketika dia baru masuk ke dalam penjara. Maksudnya dia punya first 2 or 3 months serving the sentence imprisonment, dia akan disebat. Dia tak akan disebat semasa dia nak keluar. Okay, itu tak ada human right langsung lah. Sebab bila dia nak keluar, dia disebat macam mana dia nak keluar. Okay, so selalu dia akan disebat ketika dia di awal tempoh penjara. Okay, so this is also very important. Sebab walaupun nampak sebat, dia bukan macam sebat sekolah tau ya. For your information satu kali sebat memang merah, line clear. Okay, 2-3 kali sebat kulit dah tanggal. Kulit dah tanggal. Dan cara disebat tu, cara sebatan adalah 360 punya sebatan. Okay, dan pegawai penjara yang melaksanakan hukuman sebatan for your information, they are trained to do that. There are 2 types of prison officer. Satu prison officer yang memang dia kerja dia sebat. And he was trained. Train ni maksudnya apa? Sebat di tempat yang sama. Sharp, dia macam sharp shooter. Dia sebat kali kedua pun tempat yang sama. dia tak boleh sebat di tempat yang berlainan. Kalau tak nanti dia berbilai-bilai kan. Okay. Itu akan menimbulkan kata orang something yang unpleasant to the accused, to the offender. So benda yang paling yang dia boleh buat adalah dia sebat di tempat yang sama. So you bayangkanlah, ya. Saya pernah masa saya beritahu you all lawatan ke penjara, saya pernah nampak seseorang itu disebat. Okay. 3 different person from 3 different religion. Apa similarity bila dia disebat? Ketiga-tiganya walaupun 3 different religion menyebut nama Tuhan masing-masing. Okay. Sebab dia disebat, ya. Dan ada yang orang yang begitu gagah, ya, badan dia memang badan bodybuilder, ya, bila dia disebat, ya. Sebab bila dia disebat, there will be no tines attached to you, to your body. Okay, dia akan buka, ya, tempat untuk disebat dekat you punya bahagian belakang badan, ya. Punggung, ya. Jadi bila dia disebat, hanyalah kepada tempat itu sahaja. Dan sebatan 360 ni adalah memang design dia untuk sebat, dan bila sebat dia bukan sebat sebatan tu, dia sebat dan ditarik. Okay, dia sebat dan ditarik sebab dia nak make sure satu line sahaja, tak ada banyak-banyak line. Itu adalah pegawai prison pertama. Pegawai prison kedua, train dia adalah untuk algojo, untuk menarik besi, paddle besi bagi tujuan hukuman gantung sampai mati. Okay, so they are very trained because hukuman gantung sampai mati hendaklah dilaksanakan dalam tempoh less than 5 minutes. Less than 5 minutes, actually less than 3 minutes daripada masa dia dibawa daripada satu bilik tu berdekatan dengan tali untuk dia digantung, dan tali gantung tersebut dia ada satu besi. Besi tu akan diletakkan dekat halkom offender tersebut, dan besi tersebut adalah dibuat daripada Australia. Tugas besi tersebut adalah bila orang itu dihukum gantung, dia akan terus put pressure kepada halkom dan dia akan patahkan you punya tengkuk. Patahkan offender tu punya tengkuk. Maksudnya untuk memberi efek, dia akan meninggal dunia pada masa, maksudnya pada masa serentak. Sebab dia tak naklah bila dia gantung orang tersebut tercekik dan dia tak mati. Dia macam konsep dia bila nak sembelih binatang kan, you must make sure bahawa you sembelih pada urat mereh. You tak akan biarkan haiwan tu tiba-tiba dah sembelih kemudian tak putus urat mereh, kambing tu boleh lari kan. So itu akan menyeksa binatang tersebut. So the same principle applies untuk tidak menyeksa offender. Okay, sebab itulah, ya, sebelum pindaan kepada section berkaitan hukuman gantung tersebut, ya, hukuman mati tu section berapa, ya, sebelum pelaksanaan hukuman mati tersebut, section 281, dia tak mengatakan bahawa hukuman gantung sampai mati. Dia kata hukuman gantung sahaja. So we have one case yang mana orang itu gantung dan dia ada rezeki, ya, panjang umur dia digantung dan dia masih hidup. Dia digantung dan dia masih hidup, ya. So the law has been amended, pada masa itu sebab dia dah digantung tapi dia hidup lagi. So macam mana? Lepaskanlah dia sebab dia dah digantung kan. So the law has been amended untuk mengatakan bahawa gantung sampai mati. Gantung sampai mati. Dan kita ada instances di mana pegawai penjara menceritakan kepada saya apabila dalam banyak keadaan, ya, ada keadaan-keadaan di mana apabila orang tu digantung, maknanya bila tali tu diikat dan dia punya maknanya lantai tu akan terbuka dan dia akan jatuh. Ada banyak instances sebagai contoh cerita-cerita lah, ya, banyak cerita-cerita yang perkataan tu yang tidak sedap didengar, tetapi pegawai penjara terlibat mengatakan bahawa kerana dia dah terlalu biasa, so it doesn't matter for him. Okay, sebab hukuman gantung akan dilaksanakan sebelum waktu subuh, normally dalam pukul 3-4 pagi, sebab pada masa itu badan kita masih kecut dan dia tak mengembang, ya. Jadi dia ambil kira juga faktor fisiologi, sebab kata orang tu waktu awal pagi badan kita tak mengembang, jadi dia tidak menyeksa OKT. Lepas tu mungkin you akan tanya, hukuman gantung ni akan dilaksanakan seorang-seorang ke? Tak, hukuman gantung dilaksanakan dalam satu chamber tu, death chamber. Dia ada 3 orang yang boleh digantung pada masa yang sama. Okay, dan 3 orang tu dia akan beratur di hadapan Algojo tu, pegawai penjara tersebut. Dan saja nak cerita kat you all, dia ada 3 orang. Dalam kes Mona Fendi itu oleh kerana dia berani, dia merupakan orang yang pertama di hadapan Algojo tersebut. Tapi dia punya kepala ditutup lah. Orang yang kena death sentence, dia akan ditutup kepala dia. Okay? Untuk kata orang tu mengelakkan aib yang berterusan kepada OKT. So whipping, kalau whipping pun sama juga. Whipping ni melibatkan untuk tidak menyeksa. Bukan tidak menyeksa, tetapi of course bila you kena inflicted by that whip, okay, you akan alami kecederaan, confirm. Okay, cuma kecederaan tu ikut jenis. Sebab tu ketika disebat akan ada doktor, okay, akan ada doktor. Sama juga ketika orang tu dihukum gantung akan ada doktor dan akan ada magistrate. Okay, maknanya kalau misal kata you ada rezeki besok, you jadi magistrate, dan you posting dekat Kajang, salah satu function you adalah you akan dipanggil telefon pukul 3 pagi, tuan boleh datang tak sebab kita ada hukuman gantung. We have one magistrate yang perempuan, dia memang sangat berani. Dia kerja dia setiap kata orang tu setiap bulan adalah menyaksikan hukuman gantung. Okay, dilaksanakan. Dan untuk hukuman penjara, selalunya ada yang kata kalau misal kata 24 stroke, 24 kali sebatan. Dan kalau orang tu pengsan macam mana? Ataupun dia tak boleh pada hari yang sama? Jawapannya tidak. Dia akan dirotan pada hari yang sama sebanyak 24 kali. Dia tidak akan ada penangguhan kecuali dia mengalami kesihatan yang teruk. Tetapi that is not the case lah. Sebab saya pernah lihat apabila disebat 7 kali memang punggung dia dah berdarah habis, dan bila dia bukan dilepaskan, maksudnya dia diikat sebenarnya, diikat pada satu kayu supaya dia nampak macam dia macam Captain America lah, Superman macam nak terbang kan. Dia diikat ketika dia disebat supaya mengelakkan dia daripada meronta-ronta. Dan apabila dia telah letih macam lesu kerana dah disebat 10 kali pegawai penjara buat keputusan untuk buka dia daripada kayu tersebut, dan dia terbaring dan doktor dah check, letak ubat dan sebagainya, dan apabila dia sedar semula 2-3 minit kemudian dia diikat semula dan disebat. Okay. Sebab itulah kita katakan bahawa hukuman sebatan dia meninggalkan kesan yang besar. Contoh kita ada Aming Spring, Aming Kumpulan Spring tu, lagu Bougainvillea dan sebagainya, kalau you all ingat, kalau you all minat, dia pernah menceritakan pengalaman dia bagaimana dia disebat, dan dia disebat untuk 2 pertuduhan. Yang maknanya dia disebat lebih daripada 5 kali. So bayangkanlah, kecederaan sebatan itu adalah satu kecederaan yang kekal, and it was very painful. It was very painful. It is excruciating painful. Painful tu such a small word. Okay, so sama juga dengan Salim for example. So but this is our criminal justice system. Okay, as I mentioned to you, whipping hanya dalam kes-kes tertentu, contoh dalam kes dadah dan dalam kes yang mana dia melibatkan evidence of violence or brutality, contoh sexual offences. Okay, dia memang wajib. Tapi ada juga orang kata, kalau orang tu buat vandalism, sebat dan sebagainya, okay. In Malaysia we don't have such cases, but if I will tell you in Singapore is a police state. Singapore is very strict in imposing its sentence and law. Okay. Ada satu kes melibatkan foreigner, apa yang dia buat adalah dia menconteng setiap kereta yang park dekat luar tu. Dia conteng. Okay. 3-4 kereta tu diconteng. Apa yang berlaku adalah dia telah ditangkap. Okay. Bukan setakat dia conteng kereta, dia pun conteng tong sampah awam tu. Kita conteng tak jadi apa-apa kan. Mereka conteng dan dapat ditangkap. Bayangkan orang tersebut bukan orang Singapura tau. Undang-undang di Singapura sangat ketat mengatakan bahawa if let's say that you do menconteng harta benda awam ni dikategorikan sebagai
vandalism.
Yes, vandalism. Thank you. Vandalism, dia disebat. Bayangkan dia bukan orang Singapura tapi dia disebat. Okay? Dia disebat. Dan hukuman Singapura sangat cepat dan pantas. Ada satu kes melibatkan amah Filipin. Ni saja nak cerita dengan you all. Amah Filipin dekat Singapura. Apa yang dia buat adalah agaknya dia stres ke apa ke. Singapura kan banyak rumah flat. Apa yang dia buat adalah dia baling anak baby yang dijaga tu daripada tingkat 12 dan budak tu mati. Polis tangkap dia, remand dia selama 24 jam, tangkap dia dan dakwa dia di Mahkamah Tinggi. Okay, selepas dia didapati bersalah, kurang daripada tempoh 2 minggu dia telah digantung. Bayangkan, Mona Fendi tunggu lebih daripada 12 tahun. Mona Fendi 12 tahun baru dia digantung. Kalau di Singapura kurang 2 minggu orang tu dah digantung. So saya ingat lagi masa tu Presiden Filipin cuba untuk membuat rayuan. Dan Singapore kata no, you cannot interfere into our affairs, our state affair. Sebab itu kita kata Singapore is very tough. Sebab tu bila ada orang kata bahawa oh kita Malaysia tak sepatutnya ada hukuman gantung due to human rights dan sebagainya tu. Kenapa dia orang tak pertikaikan Singapura? Kenapa Malaysia menjadi isu? Dan kenapa ramai pula yang kata orang tu makmum lah ya. Sebab kalau tanya kepada saya kena beritahu you all bahawa saya percaya setiap prinsip penghukuman tersebut dia membawa mesej supaya jenayah tersebut tidak berulang. Dan dalam Islam pun kita sentiasa percaya bahawa menjaga diri dan kehormatan kita tu adalah di antara kata orang tu daruriyat ya. Maksudnya kalau diri kita dicabul, adakah kita nak hantar orang tersebut hanya penjara? Terutama kalau melibatkan a few cases rogol, cabul, bunuh. Takkan kita nak biarkan dia dalam penjara sahaja. Dia tidak mendatangkan impak dan kesan kepada orang lain. Sebab itu kalau kita katakan kenapa setiap hukuman itu dibuat. Contohlah kan, saya ambil contoh paling mudah MCO. Yang kita akan mula besok ni. MCO, tak pakai pelitup muka kena RM1,000. Riuh sekampung. Bukan riuh sekampung ya, riuh dalam Twitter tu kan. Kenapa RM1,000? Ya? Ada yang kata, kenapa tak bagi RM5,000? Ada yang kata, kenapa kena RM1,000? Macam mana dia nak bayar? Okay? Takkan nak masuk dalam penjara, hanya tak pakai pelitup muka. Tapi you tahu tak impak yang berlaku sekarang apabila orang lalai dan leka hingga mengakibatkan sekarang ni hospital di Kuala Lumpur hampir 100% penuh dan tak boleh lagi nak menampung. Adakah kita nak ikut macam Amerika? Amerika sekarang 2.27 juta dah mati akibat COVID. Okay. Dan kalau kita kat Malaysia, kita beratur untuk bayar duit beli barang tau. Untuk beli makanan. Beli makanan. Tapi dekat Amerika, you tahu dia beratur untuk beli apa? Beli tabung oksigen. Sebab tak boleh masuk hospital dah penuh, so you terpaksa dirawat di rumah menggunakan tabung oksigen you sendiri. So diorang beratur membeli tong oksigen atau refill oksigen sebab diorang ada family members yang dah kena COVID di rumah. Sebab itulah kita katakan bahawa sama juga kes rogol dan kes rompak, kes curi motor. Okay, dan sebagainya, which is rampant nowadays. Sebab itu, adakah sistem keadilan kita tidak cukup? Adakah hukuman kita tidak cukup untuk menyedarkan orang? Tak semestinya ya, kita untuk ada the best mechanism to make sure bahawa the principle of sentencing will serve its purpose. Okay, will serve its purpose for the untuk memastikan bahawa keadilan public interest itu tercapai. Okay. Alright, section 173A dengan section 294 tu you boleh refer kepada page 584 dan 585. I believe at this juncture saya mohon you all untuk baca dan faham ya. Saya tahu kadang-kadang benda ni confuse tetapi dia ada perbezaan yang saya rasa saya dah maklum pada you all dalam sesi yang lepas ya. Lecture yang lepas berkaitan ya. Dan last kali kita ada community service. Community service ni section 293 has been amended ya. Kalau you all masih ingat ada apa? Dulu dipanggil PLKN, latihan khidmat negara ya. Dia lebih kurang macam community service lah untuk saya ya. Tapi PLKN saya tak pasti lagi ke tidak ya. Community service ni konsep dia adalah dia memberikan kata orang tu offender ni akan dilepaskan dan mana dia akan serve sentence for community service, for example under section 2931E, not exceeding 240 hours in aggregate. in such nature and such time and place subject to condition. And community service means any work, service or course of instruction for the betterment of the public at large, and include any work performed which involve payment to the prison or local authority. Sekarang pun kalau in line of kata orang tu prison community service, salah satu lagi alternatif kepada penjara adalah kalau misal kata seseorang itu dikenakan hukuman penjara bagi kesalahan yang tidak berat, dia ada satu konsep yang diberi nama sebagai banduan prabebas. Maksudnya, katalah dalam tempoh 3 tahun dan dia melihat bahawa you berkelakuan baik, maknanya offender tu berkelakuan baik, dan dia akan ada remission ataupun discount 2/3 yang saya bagi tahu tadi. Dan waktu prabebas ni maksudnya dia boleh keluar daripada compound penjara tersebut untuk buat craft contoh, untuk menjana pendapatan bagi diri dia. Dia masih lagi di penjara, tetapi kata orang tu dalam tempoh untuk dibebaskan, jadi dia agak ringan untuk dia, maknanya dia tak akan dipenjarakan. Tapi untuk kes-kes melibatkan kes-kes ringan sahaja, kes-kes yang ringan sahaja. Alright, ada apa-apa soalan? Community service ni pun you kena lihat juga ada beberapa macam, kalau dapat lihat tujuan dia adalah juga melibatkan rehabilitation, providing social responsibility, making community service worthwhile experience for the offender. Dia juga adalah reparation by providing an avenue for offender to make amend and providing tangible benefit to the community. And it is also a type of punishment to by depriving offender of his free time and placing an obligation on him to work during that time. So kan ingatlah 5 perkara sebelum datang 5 perkara if you still remember. Dan waktu senang maksudnya waktu lapang adalah salah satu perkara yang kita kena betul-betul appreciate. Kerana apabila waktu itu telah diambil daripada kita, apabila kita sakit sebagai contoh, kita akan kata orang tu nikmat makan, nikmat untuk mengecapi sesuatu, even our free time adalah sesuatu yang kita rasa akan diragut daripada kita lah kan, kalau misal kata kita terlibat dengan hukuman-hukuman ini. Alright, okay, ada soalan? Okay, kita dah bincang berkaitan dengan mitigation dan juga aggravated factor pada minggu lepas. Saya rasa kita dah bincang sikit berkaitan aggravated factor. Saya rasa kita bincang sikit tentang mitigating factor. Tapi sebelum tu saya nak tanya, you all punya tutorial dengan practitioners dah bincang ke tentang mitigating factor?
Ada.
Ada? Ada ke?
Ada sikit-sikit je dia sebut.
Ada sikit-sikit je disebut. Okey. Tak apalah, kita sebut lebih-lebih sikit dalam ni. Okey. Apa maksud mitigating factor? Mitigating factor adalah apa? Mitigating factor ni apa? Kita boleh tengok dalam beberapa kes contohnya kalau kita dapat lihat dia macam satu rayuan ringkas. Kenapa saya kata rayuan ringkas? Ini ayat saya. Rayuan ringkas ni bermaksud dia ada 2 jenis rayuan. Satu rayuan ni untuk meringankan hukuman. Satu lagi rayuan untuk to review the legality, bukan the legality, maksudnya appeal yang dimaksud kalau saya ada bincang tadi Okey, dia ada 2 jenis. Satu adalah rayuan untuk mengurangkan hukuman, meaning that appeal as to mitigate, appeal as to mitigate so that you can get the lower sentence. Satu lagi adalah appeal against sentence. Okay, appeal against sentence. Rayuan untuk mengurangkan hukuman ini selalunya bermula selepas OKT disabitkan dengan kesalahan. Okay. Dan sebelum OKT dihukum. Okay. Sebelum OKT dihukum ataupun diberikan hukuman. Okay. Untuk maksudnya selang masa itu adalah pada masa Katalah okey, simpulan bin simpulan, mahkamah mendapati berdasarkan kepada keputusan berdasarkan kepada keterangan, based on the evidence and based on the witnesses. Okay, so the prosecution had successfully proved the case beyond reasonable doubt, and therefore the court found you guilty. The court found you guilty, okay, and will convict you with the offence. Court dapati awak bersalah dan awak akan disabitkan dengan kesalahan. Okay, so the court sebelum memberi atau menjatuhkan hukuman, okay, maka mahkamah akan invite OKT, okay, untuk merayu to forward the mitigating factor. Okay, so the mitigating factor yang standard, sebab nanti kalau ada rezeki you all chambering, you all akan ada satu sesi, kata orang tu sesi latihan dalam kamar chambering ni dengan legal aid. Dan salah satu benda popular dan famous legal aid ni adalah untuk buat mitigating factor on behalf of the accused person, macam masa saya chambering dulu, ini adalah salah satu saya pun kata apa agaknya yang what should I say on behalf of my client in terms of mitigating factor. Rupa-rupanya lawyer ni dia dah ada standard template, dan standard template tersebut adalah muka surat 591 591 dan 592. Okay, in which normally the accused person akan cakap berkaitan dengan umur mereka. Okay, age of offender. Kenapa umur, ya? Adakah umur itu akan memberi pengaruh yang besar? If let's say kalau umur tersebut adalah umur yang terlalu tua, dia akan jadi lebih efektif. Sebab apa? Umur yang tua maka tidak boleh dikenakan hukuman yang berat. Kalau umur tu umur yang sedang-sedang, ya, maksudnya umur 21 sampai umur 45 atau umur 21 sampai umur 50. Maksudnya you tengah tegap lah tu, ya. Macam Remy Ishak lah tegap dia kan. So dalam kategori umur tersebut, you boleh katakan bahawa pada usia tersebut, you boleh kaitkan dengan usia yang mana you boleh menyumbang kepada keluarga. Maksudnya you adalah breadwinner of the family since umur OKT adalah berusia 30 tahun. OKT masih lagi ada peluang untuk kembali ke pangkal jalan, okay? Dan ada peluang untuk berbakti kepada family. Itu kalau umur yang sedang-sedang. Dan kalau usia yang terlalu muda, you actually suggested the court untuk pass sentence berdasarkan kepada because at a young age there is a possibility for rehabilitation. Itulah maksud dia. Itu satu umur. Dua, record of the offender. Record of the offender ni adalah rekod jenayah. Jenayah lampau dia. Ada ataupun tidak rekod jenayah lampau tersebut. Okay. Yang ketiga adalah plea of guilty. Okay. Yang arif oleh kerana OKT mengaku salah dalam kes ini. Maka ia merupakan satu faktor yang mana OKT telah insaf dengan kesalahan dia. Dan dalam konteks ini, dia adalah sebenarnya telah menjimatkan masa mahkamah. Okay. Dan juga menjimatkan kos awam, ya, yang perlu ditanggung bagi setiap prosiding jenayah. Okay. OKT telah insaf, oleh kerana itu OKT mengaku salah. Dan dia telah pun membolehkan kes ini dapat diselesaikan dengan kadar yang segera. Itu adalah satu, kata orang tu, nanti kalau misal kata you buatlah exercise berkaitan dengan mitigating factor. Satu lagi adalah gap principle. Apa yang maksudkan dengan gap principle ni? Okay, apa yang dimaksudkan dengan gap principle? Anybody?
Semakin lama semakin baik.
Semakin lama semakin baik.
Bermaksud daripada offense yang pertama kepada offense yang kedua tu ada gap yang lama.
Okay, semakin lama semakin baik. Previous conviction and the present offence should be viewed as a mitigating factor rather than aggravating factor. Maknanya the longer the gap, the greater the mitigating effect. Okay, itu adalah the gap principle. Yang seterusnya, condition or circumstances before commission of the offence. Adakah melibatkan provocation? Okay, you belajar kan dalam penal code. They are substantive defense. I call it substantive defense. Contoh, dia ada keadaan yang mana jenayah tersebut dilakukan oleh kerana orang itu tidak berniat dan dia berlaku oleh kerana provocation. Okay. Kalau masih ingat lagi ada satu kes tu, saya lupa lah, dia berkaitan dengan kes OKT tu membunuh mak mertua dia oleh kerana pada masa itu perut dia sangat sakit. Saya ingat lagi kes tu, saya lupa nama dia. Perut dia sangat sakit, memang dia tengah sakit. Sekali mak mertua dia jenis membebel tak sudah. Menyalahkan dia tak menjaga wife dia dengan baik dan sebagainya. So apa yang lelaki tu buat adalah dia terus bunuh mak mertua dia. So it's on provocation. So court mengatakan it must be based on the sudden and grave provocation. Okay. Sama juga kadang-kadang kita ada banyak kadang-kadang variety of cases kat mahkamah ni. Kadang-kadang nak gelak, tak tahu nak gelak atau tidak. Melibatkan contoh pernah ada yang mana mak mertua dan juga menantu didakwa. Menantu didakwa kerana melempang mak mertua. So dia kata provocation. Ataupun dia kata bahawa pada masa tersebut hilang pertimbangan dia. Hilang betul pertimbangan dia oleh kerana dia telah diprovoke. So test dia adalah sudden and grave provocation without any time maksudnya tidak ada tempoh untuk dia berfikir. Kalau dia kata dia sudden and grave provocation, you masih ingat lagi tak? Sudden and grave provocation, tapi dia ada masa pergi ke dapur, ambil pisau, lepas tu bunuh. Itu bukan sudden and grave. Okay, sebab dia boleh berfikir. Sudden and grave ni adalah pada masa tu hilang pertimbangan akal orang yang sihat oleh kerana provocation tersebut. Nombor 2 adalah drunkenness, intoxication. Okay, dia mabuk, mungkin menjadi sebab. Consent. Okay, consent. Ini kalau consent ni kalau misal kata adanya kata orang persetujuan daripada mangsa, contoh gitulah. Kita ada banyak kes berkaitan dengan kata orang tu kes rape, kes jenayah rogol, yang mana banyak keadaan apabila dibawa di mahkamah, OKT mengatakan bahawa mangsa bersetuju, rela untuk dilakukan sedemikian rupa. Dan ada yang mengatakan bahawa, jadi dia nak mengatakan bahawa rogol adalah something which is unconsented. Maksudnya sesuatu yang tidak rela, tanpa kerelaan. Jadi dengan faktor consent ni, maksudnya kerelaan ni akan mungkin dapat mengurangkan katanya lah dan juga kalau kita dapat lihat other domestic emotional crisis, financial problem, instigation. Ingat tak saya bagi contoh berkaitan dengan seorang yang ada 2 kes melibatkan curi tin susu. Curi susu formula bayi. Satu adalah kita dapat lihat bahawa dia gantung tak bertali, dia tidak bekerja, dia tidak ada duit. Dan kata orang tu apabila faktor ekonomi itu sangat penting, di mana apabila berlaku krisis ekonomi, berlakulah juga peningkatan dalam kadar jenayah. Sama juga kalau dalam Islam, kalau kita fakir, kita akan membawa kepada kekufuran. Pada satu tahap tertentu. Jadi dia juga boleh jadikan satu faktor lah untuk dijadikan mitigation. Kemudian effect of conviction and sentence. Apa efek dia? Contoh dia mengatakan bahawa kalau saya dihukum penjara, saya ada bayi. Bayi itu menyusu badan, kata. Saya dah anak-anak kecil, tak ada orang nak jaga anak-anak saya. Pernah satu masa dia banyak cerita-cerita kehidupan kalau dekat mahkamah ni kan. Cuma saya tak mampu dapat novel je lah. Ada yang mana ibu dia adalah tempat bergantung dia itulah laki dia seorang. Tapi laki dia telah pun ditangkap atas kes jenayah yang mana wife dia tak tahu husband dia sebenarnya adalah pengedar dadah. Jadi dia ada anak dia terlalu kecil. Tak boleh bawa pergi court. Tak boleh masuk dalam courtroom. Jadi oleh sebab itulah kita dekat setiap court tu ada macam legal aid center. Jadi dia letak anak dia tu dekat legal aid center untuk dijaga sebentar. Sebab dia kena masuk dekat dalam courtroom. Itu satu. Kemudian dia mengatakan bahawa dia breadwinner of the family. Kalau saya tak ada wife saya, anak saya, sekolah dan sebagainya. So, the family of offender and also the job and other privileges. Ada yang to the extent mengatakan kalau saya dihukum, saya ada ibu bapa yang tidak ada orang menjaga. Mereka sangat uzur. Sangat uzur. Ibu saya duduk dekat kerusi roda, ayah saya buta, seorang yang tak nampak. Okay? Kita tak boleh lah tiba-tiba judge kan, kau dah tahu macam tu, siapa suruh kau buat kan? Tak boleh cakap macam tu. Oleh kerana kadang-kala faktor-faktor dia ada keadaan yang mana betul lah manusia ni tidak perfect. Okay? Dan kadang-kala manusia ni terbuka kepada melakukan kesilapan. Okay? Walaupun kita kata dia bukan satu asas untuk kita berbuat kesilapan, tetapi contoh dalam kes rasuah kan, kes rasuah. Apabila ada peluang di depan mata dan kemudian kita pula banyak hutang keliling pinggang dan kita memerlukan duit pada masa yang sama. Jadi bila orang hulu, kita tak minta, kita ambil je. Okay? Dan bila ada peluang, kita kena ingat kes jenayah ni adalah berpaksikan kepada peluang. Peluang tu kadang-kadang kita tak perasan. Kita dekat dalam college, kita beli handphone baru, letak atas meja, pintu kita tak kunci. Kita pergi ke toilet contoh. Itu peluang kepada orang masuk dan curi. Okay? Dan banyak-banyak peluang yang lain. Okay? Sama juga, sebab itu kes-kes jenayah ni adalah satu yang mana dia memberi impact sosial kepada seseorang. Dan itu kita boleh katakan bahawa satu mitigation kepada orang ni. Conduct of the offenders. Pernah ada dalam satu kes yang mana seorang ayah ditangkap kerana melempang mangsa. Kenapa ayah ni melempang mangsa? Sebab mangsa telah merogol anak dia. Ini cerita betul di satu daerah. Okay. Saya pun terkejut apabila kes tu dibawa di depan saya. Jadi bila kita kata, kenapa pula polis tak tangkap orang yang dilempang tu, mangsa tu, sebab mangsa tu dituduh merogol. Okay. Tapi ayah ni pula yang ditahan kerana melempang. Section 323 mendatangkan kecederaan tanpa menggunakan senjata. Okay. 323 kanun keseksaan. Jadi kemudian dia merasa bersalah, dia bayar ganti rugi, dia pergi tanggung kos rawatan, kos rawatan dan sebagainya tu, dan beri ganti rugi, serta dia cooperate dengan pihak polis. Dia bekerjasama dengan pihak polis ketika menjalankan siasatan. Perkara-perkara ini dikategorikan sebagai conduct ataupun perlakuan pesalah tersebut boleh dijadikan faktor untuk mitigation. Okay, maksudnya dia boleh kata bahawa dia telah bertaubat, dia telah insaf, dia telah memberikan pampasan yang sewajarnya. Ada kes yang mana melibatkan mak dan ayah dia dibunuh oleh kerana kes itu melibatkan robbery. Okay, robbery bersenjata. Mak ayah dia telah dibunuh. Jadi OKT telah pun sebelum dia ditahan, dia telah berpesan kepada ahli keluarga dia untuk membayar ganti rugi, kasih duit untuk anak-anak mangsa ni pergi bersekolah, dan dihantar ke pusat yang mana jagaan kerana anak-anak ni masih kecil. Itu sebenarnya boleh dijadikan faktor mitigasi. But again, it depends on the situation. It depends on the situation. Betul lah, awak telah pun bertaubat dan memberi tuntutan pampasan ganti rugi. Tetapi kesan yang awak buat itu adalah kesan yang sangat teruk kepada mangsa. Itu maknanya depends on the hakim nanti untuk menjatuhkan hukuman. Tapi for mitigation purposes adalah ada juga faktor lain. Contoh adalah saya dah ditahan terlalu lama. Contoh kan. Okay, saya dah ditahan terlalu lama. Jadi saya mohonlah bahawa kalaulah saya dijatuhkan dengan hukuman tersebut, agar hukuman penjara itu dari tarikh tangkap. Okay, bukan daripada tarikh dihukum. Okay, ataupun saya ada masalah kesihatan. Okay, pada satu pagi masa tu saya berkhidmat di mahkamah kan, saya menerima panggilan telefon. Ya.
Maaf, kami ada kelas sekarang.
Oh, alright, sorry. Ada kelas pukul 11 Alright, okay. Okay, tak apa kalau macam tu. Alright, okay. Baru nak cerita tapi tak apa. Okay, so kita settle hari ni dengan mitigation. So, thank you guys for coming.
Tapi sir, boleh saya selit sekejap sebelum kita habiskan kelas?
Ya, ya.
Saya ada beberapa perkara. Berkenaan assignment kita, ada yang minta untuk assignment CPC kita, ada yang minta untuk kita extend. Sepatutnya
Okey.
hantar minggu ni.
Alright.
Lepas tu ada yang minta untuk doktor consider lah untuk extend mungkin lagi seminggu ke. Saya sampaikan je. Lepas tu
Okey.
yang kedua, ADR pun kan ada 2 assignment. Mungkin doktor boleh consider buat salah satu.
Buat salah satu? Okey, okey, tak apa. Nanti saya
Kita consider lah.
nanti saya, sebab ADR ada 2 assignment. Assignment itu adalah I think the first assignment on mediation kan. Mediation punya tu, and it was actually a firm task. Secondly itu adalah individual. Tapi tak apalah, nanti saya lihat dan apa-apa pun nanti saya akan bagi tahu pada Ashraf later on.
Okay, baik.
Alright, okay. Right, thank you guys. Thank you for coming. Okay, insyaAllah kita jumpa lagi hari Jumaat ni. Okay, stay safe. Kita mula MCO besok. Jaga diri baik-baik. Right, okay. Assalamualaikum.
Assalamualaikum. Thank you, sir.
Thank you, doktor.
Thank you, sir. Assalamualaikum.